Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session, please press star 1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I'd like to turn the meeting over to Melissa Grosso. Thank you. You may begin.
Great. Thank you so much. And good morning, good afternoon, everyone. Thank you so much for joining us for our first of 17 webinars in our Export Compliance webinar series. Today we're going to be talking about the Bureau of Industry and Security from an introductory perspective. Before we get started with the official presentation, I just wanted to go over a couple quick housekeeping items. As I mentioned in the emails that you received, you will receive the net replay of this webinar as well as a PDF copy of the slides. So you'll be getting that a little later on this afternoon. We will have a formal Q&A session where you can ask the speaker any questions that you like. That will be, the formal Q&A will be after the formal presentation. However, if you do have questions during the presentation, on the right-hand side of your screen, you should see a Q&A box, and you could just type those in at any point during the presentation. I wanted to make a quick introduction of the U.S. Commercial Service. I know many of the participants on the webinar are familiar with the U.S. Commercial Service and have worked with us in the past. For those of you who haven't, we are the trade promotion arm of the U.S. federal government. As you can see from the, well, maybe you can't see it, it's very small type on the graphics. We have offices throughout the United States as well as in about 75 countries at U.S. embassies and consulates. And our main job is really to help U.S. companies develop and execute their exporting plans. So that's what we do day in and day out. If you are, as I mentioned, we have offices across the country. If you go to our website, which is www.export.gov, you can just type in your zip code and you'll be directed to your local U.S. Export Assistance Center. So I definitely recommend that you get connected with our offices. We have a lot of good market intelligence, and we can connect you with partners all over the world. One of the critical components that we always counsel companies on is having a robust export compliance plan, which is the reason that we put this 17-part series together. So kudos to you all for signing up for the webinar. It is a critical factor in any company's compliance program. As you can see on this slide, we have a couple additional webinars coming up this next month. I know most of you have signed up for the full 17-part series. For those of you who haven't, you might want to consider signing up for some additional webinars. And with that, I'd like to offer sincere thanks to Tahlia Townsend, who's our speaker on today's webinar. Tahlia is a partner with the law firm Wiggin and Dana, LLP. I definitely encourage you to go to the Wiggin and Dana website. She has quite an interesting bio. I'll give you a little bit of background on Tahlia. She's a graduate of Yale Law School, a former federal law clerk, and she co-chairs the International Trade Compliance Practice at Wiggin and Dana. And she essentially works she has worked for Fortune 50 defense contractors, also universities and small businesses to litigate civil issues, to interpret various aspects of the ITAR, the EAR, and other U.S. sanction regulations. Again, I definitely recommend that you take a look at Tahlia's bio. She has some interesting cases that she's litigated and definitely an interesting educational background. So with that, again, I thank you, Tahlia, for joining us, and I will turn things over to you.
Great. Thank you very much, Melissa, and thanks to everyone for joining. I will try and move pretty quickly through this material. We've got a lot to cover today. The world of the EAR and BIS is pretty large, pretty vast. I know we have a mixture of experience on the line. I can tell from the titles that we have some folks who spend a lot of time with trade compliance and others who don't. So I am going to begin with a brief overview of the entire export control regime, just to make sure that everybody's on the same page and that I don't confuse you by immediately jumping into the details of BIS and the EAR. And I will keep an eye on the questions. We'll try and address anything that is critical to understanding during the presentation, and then we'll loop back to get the other questions at the end. So as to keep us on track and not cause you to be here later than you intended to be. So with that, let me dive in. I'm going to talk today about BIS. Here's the agenda. We're going to do a quick overview, as I mentioned. We're going to do an overview then of BIS, and then we're going to talk about, in some detail, about the types of controls that apply in this area and how you get authorization to export, and some corners of the EAR that are less familiar to people, the anti-boycott requirements in particular. And then if we have time, we'll talk a little bit about investigations and disclosures as well. All right, so quick 50,000-foot overview of U.S. export controls. Key principles. For folks who don't already know, in the U.S., export is considered a privilege, not a right. And what that means in practice is that under U.S. law, you have to be able to identify some kind of government authorization for all exports and re-exports of controlled goods, data, and services. And when I say all exports, I really mean that. Even goods that you may not think of as sensitive must have authorization before you can send them out of the country. And that includes, as you can see from the little pictures here, items that you consider very innocuous, like rubber gloves for dishwashing or gardening, items that include information, like the little blueprint of the Star Trek Enterprise you can see there, and things that you might consider more sensitive, like titanium bars and UAVs or drones. Right? All of those things are within the scope of U.S. export law, even the non-sensitive ones. I just want to make sure that everybody is aware of that right up front. So what is an export? If you need authorization for it, it would be helpful to know what it is that you need authorization for. Some of this is very obvious. If you are sending something out of the United States, whether that something is hardware or information or services, if it's going out of the United States, that is an export. And if it's going from one foreign country to another after having gone from the United States, so it goes from the U.S. to France and then France to Germany, or the U.S. to Germany and then Germany to Singapore, that piece, the transfer from one foreign country to another, is a re-export. And if the original export was subject to U.S. law, then that additional retransfer will also be subject to U.S. export law. So foreign subsidiaries of your companies, if you have any, need to be aware of this. And your foreign customers also need to be aware of it, because if you are selling them U.S. goods and they plan to transfer those again, they need to be aware that U.S. law is sticky and is going to follow their possession of the goods. It also extends to the release of controlled information, which we call data or technology under the EAR, and software. And a release can include an oral or visual disclosure. So I just want to pause for a second to think about the ramifications of that. That means that if the information that you are in possession of is controlled, and we're going to talk about what information that is in a few minutes, but if it is controlled, if you release it, including by having a conversation about it, or including by providing documents that contain that information, or including perhaps by showing a piece of hardware that reveals controlled information, any kind of oral or visual disclosure may also be an export. If it is to a foreign person, whether that foreign person is in a foreign country or right here in the United States. So if you have a foreign friend visiting you and you have controlled data, if you have a foreign visitor at your facility, if you have a foreign customer come to the facility, all of these can result in exports. And finally, a transfer within a foreign country from one location to another is also a controlled event, and that's known as an in-country transfer. So as you can see, it's a very broad scope of controls. To make this a little more concrete, I wanted to point out some real concrete examples of exports. The obvious one is foreign sales. I'm sure you figured out if you're putting something in a box and selling it to a foreign customer and sending it out of the country via FedEx, that's an export. But it's also an export if you take goods overseas to a trade show, whether you take them in your suitcase or put them in a box and send them with a courier. Either way, you are exporting those items. And when you're at the trade show and you're providing information to foreign persons at that overseas trade show, that could also be considered an export, and it depends whether the information that you're exchanging with them is controlled or not. If you're collaborating with foreign design partners, or indeed with U.S. partners in a foreign location, that could also involve exports of information during the collaboration process, or perhaps hardware during the collaboration process. Working with foreign graduate students if you are at a university, or if you're at a private company that's sponsoring university research, that can result in exports too. If you have foreign visitors and they have physical access, or foreign employees and they have access to information on your computer network, that can also result in exports. And traveling overseas with your computer stuffed full of interesting company data that may be controlled, that would also be an export. But also the information that is attached to your emails in your cell phone, that would also be an export of the data on your cell phone. There are other ways that exports often come up would include sending hardware overseas for repair, or if your customers send you hardware to be repaired and you send it back to them. When it comes into the United States, it becomes subject to U.S. law, and when you send it out again, that's an export. And similarly, if you are storing data in the cloud, and if the cloud is not a U.S.-only cloud, that is, if it is putting data on servers that are not in the United States, like all those lovely server farms in Iceland where they don't have to pay for air conditioning, that is an export too. And finally, another good example that people often don't think of would be if you have IT providers who are not located in the U.S., that help desk service that is being staffed out of a foreign country so that they can provide round-the-clock service, that can involve giving those foreign IT providers access to your system and your information, and that can result in exports too. So I hope by this point you're feeling, somewhat concerned about the range of exports and the breadth of export law and motivated to continue listening. So who has to comply with these controls? Well, if you're a U.S. person, doesn't matter where you are in the world, you have to comply with the controls. If you're a foreign person and you're in the U.S., you have to comply. And if you're a foreign person who has control and custody of goods or data or software that are subject to U.S. law, then you also have to comply. There are some circumstances in which foreign subsidiaries of U.S. companies also have to comply. Those are rarer examples, but there are some areas of the law that require it. So what's a foreign person and what's a U.S. person? Well, a U.S. person is a U.S. citizen. That part's obvious. Also a lawful permanent resident or green card holder. But if you have a foreign employee who does not have a green card, that is, if they're here on a work visa, then they are a foreign person, and as we saw before, transferring information to them can be an export. Protected persons and who are, for example, asylum seekers who've been granted asylum, U.S. government entities, and entities that are incorporated or otherwise organized to do business in the U.S. Those are all U.S. persons. But everybody else is a foreign person, and that means that you need to be aware of those folks because transferring information to them can constitute an export. And finally, before we move on to talking in detail about BIS, it's helpful to know who regulates exports. Well, today's topic is one of the agencies that regulates exports, and that's the Department of Commerce. And within the Department of Commerce, the Bureau of Industry and Security, or BIS. And the way that the BIS achieves its mission is largely through the Export Administration Regulations. That's the big rule book that we all have to be familiar with so as not to get ourselves in trouble here. And the Export Administration Regulations describe the rules that apply predominantly to commercial items and dual-use items, that is, items that could be used for commercial or military purposes, but also, at least for the last several years, some less sensitive military items. Those are also subject to control by the Export Administration Regulations. And the way you know whether something is controlled by the Export Administration Regulations is that it is either described on the Commerce Control List, referred to as the CCL, which is a great big list of all the items, of many items that are controlled, and then other items that are not sensitive enough to warrant description on the CCL, but which are subject to the EAR, and those are EAR 99 items, which we will talk about in a few minutes. But in addition to the Department of Commerce, it's important to be aware that the Department of State also exercises authority over exports, does it through the International Traffic in Arms Regulations, or ITAR, and that is predominantly for military-related goods, military items, military information, and military-related services. And those are described on the USML, the U.S. Munitions List. There are some other agencies that occasionally have jurisdiction over export. We're not going to talk about them in detail today, but the Office of Foreign Assets Control, which is part of the Department of Treasury, and the NRC and the DOE, which exercise some authority over nuclear-related exports. So if you are doing business in sanctioned countries, or if you have nuclear-related business, then you may need to be aware of those agencies as well. But today we're going to talk about the Department of Commerce. So let's talk about the Bureau of Industry and Security, BIS. As I mentioned, BIS regulates items, exports of items that are subject to the EAR, the Export Administration Regulations. And you can find the EAR by looking up the site there, 15 CFR 730 to 774. It will be important if you have to spend a lot of time with this to actually look at the text of the regulations. In addition to actual exports of hardware and software and information, there are some circumstances in which BIS regulates services provided by U.S. persons. There are fewer circumstances in which BIS regulates services than the ITAR, for those of you who are ITAR experts, but there are still some, and predominantly when those services would further nuclear, missile, chemical, or biological weapon proliferation. And then there is this little corner of the EAR that is actually quite important if you're doing business in the Middle East, and it regulates activities that might help foreign countries to carry out boycotts that the U.S. doesn't approve of. And we're going to talk a little bit about those anti-boycott regulations as well today. So we said that the BIS regulates the export of items that are subject to the Export Administration Regulations, EAR. And what are those items? Well, it is a very, very, very broad bucket. We're going to talk about the exceptions in a minute, but it's important to be aware how broad the range of items that are subject to the EAR and therefore require authorization for export really is. Broadly speaking, if an item is in the U.S., then there is a good chance that it is subject to the EAR. And that means, for example, if somebody sends you data from outside the U.S. and it enters the U.S., it becomes subject to the EAR. That's important to bear in mind. It's also applicable to items outside the U.S. if they have more than a certain de minimis level of U.S. content. So you can imagine already that for foreign companies, it's very important to know about this, because if they are buying U.S. products and incorporating them into their products, they may end up with a product that is subject to U.S. law. And for your foreign customers and your foreign subsidiaries, that's important to know. The amount of U.S. content required varies. It's a complicated kind of rule. I'm not going to talk about it in detail today, but generally speaking, between 10 and 25% should cause you to investigate whether the EAR applies. Items outside the U.S. that are derived from U.S. technology can also be subject to the EAR. That, again, is a very complicated rule, but it's a red flag to know about and think about and analyze if you have products outside the U.S. that are derived from U.S. technology. So what are the exceptions? Well, if the items are subject to the USML, that is the United States Munitions List, that is military items, not all military items, because some are now subject to the EAR, but a good number of them are subject to the USML trumps, and the USML will control in those circumstances, not the EAR. If the items are data, that is only information, this doesn't apply to hardware, and if they can be described as they satisfy the definition of fundamental research, which is information resulting from research in science or engineering that is intended to be published without any kind of restriction, then those items are also not subject to the EAR. Similarly, published information that's made available pretty much to anybody in the public with the consent of the rights holder and without any restrictions, that is also not subject to the EAR. And finally, if the U.S. government approves the release of information that would otherwise be subject to the EAR, then it is no longer subject to the EAR. So there are exceptions, but it is nonetheless an extremely broad bucket that is subject to the EAR. So considering how huge the bucket is, and considering the broad range of activities that folks on the phone today are involved in, it's pretty likely, if you're engaged in any kind of international activity, that at some point you will need to export something that is subject to the EAR. And so if that's the case, and remember how broad the definition of export was, remember that if you need to export it by sharing it with foreign employees, or by sending it out of the country, or by having foreign visitors come and look at it, or by taking it on your laptop, in any of those circumstances, you are going to need authorization in order to perform that export, or if you're already overseas, that re-export. 3 types of authorization under the EAR. You can get a license, which is an actual written document that you apply for from BIS. It's valid only for the items that it describes and the recipients that are specified in it, and it's only valid for 4 years. So it requires application, and it's quite narrow when you do receive it. There's a license exception, which would be basically a license that is available to everybody, and it's written into the regulations. You can use it as long as you can comply with all of its conditions. You don't have to ask BIS in advance, but you do have to satisfy the conditions, and you do have to make a record of using it. And then the final bucket, the bucket everybody really wants to be in, is the bucket of no license required. And this is a type of authorization, and it applies to items that, surprise, surprise, don't require a license or a license exception. Generally speaking, these are going to be less sensitive items, but not in all cases. There are cases in which even very, very non-sensitive items like rubber gloves require a license for you to be able to export them. What it's going to depend on, that is, whether you need a license or not, what that's going to depend on really depends on three factors. The classification of the item, which means where the item is described on the CCL, on the Commerce Control List, the big list I mentioned of items. But it also depends on the country that you want to send the item to. Sometimes you need a license for one country, but not for another country. So the classification and the country both count. And then the broadest set of restrictions actually depend on the end user, that is who you are sending the item to, and the end use, what they want to use it for. There are end user and end use restrictions that apply very broadly to all kinds of items, no matter how they are classified and no matter what country they're going to. And those, therefore, are very broad controls. They have the most general applicability. They're most likely to affect you no matter what your business is, and so we're going to talk about them first. I call them comprehensive controls, and they relate to, as I said, countries, end users, and end uses. At a very high level, essentially, there are a whole bunch of transactions which, unless you get a license or can identify a license exception, the EAR prohibits. And these are transactions, and again, that's exports and re-exports and in-country transfers, involving certain prohibited countries, certain prohibited end uses, and prohibited end users. And you can find those countries, end uses, and end users in the parts of the EAR that are referenced here. I want to point out again that these restrictions apply even to very non-sensitive goods, like rubber gloves, like printer cables, like bottles of sparkling water. Really anything you can imagine, even if it's not at all sensitive, could be subject to these controls. And I also want to point out that it is a violation to send items to prohibited countries, end users, or end uses if you know or have reason to know about those prohibited countries, end users, or end uses. So it's a very low liability standard, and that's important, for example, for logistics providers. It's not your stuff that you are helping to ship out of the country, but if you have some reason to believe that it is going to a prohibited place or for a prohibited purpose, you could be liable too, not just the original exporter. So it's pretty important to be aware of these. What are the prohibited countries? We could spend hours talking about the types of prohibitions that apply here, and we're not going to do that today, but it's important to be aware that if you see the name of one of these countries associated with the transaction, that's a red flag. You need to study the matter further. There are very comprehensive controls. No matter what you read in the newspaper these days about Cuba, nonetheless, there still are very, very broad controls on exports to Cuba, Iran, North Korea, and Syria. There are also more targeted controls, narrower controls that apply to the Crimea region of Ukraine, also claimed by Russia, and indeed to certain parts of entities in Russia, and Iraq. In addition, it is not an EAR issue, but you need to be aware that there are controls on Sudan that are administered by OFAC. There is a broad general license that allows those these days, but still, if you see Sudan, you also need to investigate further, although that's not specifically an EAR issue. So, prohibited countries. See one of these countries? Definitely get in touch with your export control officer. How about prohibited end uses? It's important to be aware what your customers or other third parties overseas plan to use items for before you export them. Nuclear proliferation is a problem. If you have any reason to believe that nuclear proliferation might result, then you need to not perform the transaction without further guidance. Rocket systems, development of rocket systems. and missiles. And by the way, missiles are defined to include some unmanned aerial vehicles or drones, depending on their range and their ability to carry, because those kinds of drones can be used as weapons, and so they're defined within the definition of missile. So development of rocket systems, chemical and biological weapons, certain kinds of maritime nuclear propulsion. Those ones probably pretty obvious. There are others that are more difficult to navigate. You do require a license or a license exception in order to export even commercial items for military end uses in certain countries, in particular China, Russia, and Venezuela. So it's a tricky one to look out for. You may be exporting something completely commercial, but if it's going to military end uses in those countries, then a license requirement may attach. Similarly, microprocessors and certain kinds of camera systems can't be exported for military end uses without a license or license authorization, so you need to watch out for those too. And then this one is particularly odd if there are any aircraft manufacturers or aircraft service providers, people who provide spare parts for aircraft or other kinds of equipment for aircraft. It's an important one to know about. When you export goods for a foreign aircraft end use, you have to have authorization not only for the country that the aircraft is sitting in, but also for the country in which the aircraft is registered and the country that is controlling the aircraft, that is, the country of the person who's chartering it or who owns it or who's leasing it. And if you don't have all of those authorizations, then that's a prohibited end use, and it's a violation of the EAR. So prohibited countries, prohibited end uses, and prohibited end users. And again, the reason that I'm going on at such length about these three categories is that they apply very broadly to any kind of goods, even things that you wouldn't think about as being sensitive. So the prohibited end users are those entities that, which can include corporations, it can include governments, include individuals, that the U.S. government considers to be involved in proliferating weapons of mass destruction, in terrorist activities, other kinds of activities that threaten our national security or foreign policy, also certain particular Russian entities, certain military end users, and a whole bunch of entities that are sanctioned by the Office of Foreign Assets Control or the State Department. How do you know if any of those parties are involved? Well, first you have to be careful to identify all the parties to a transaction, and then you need to check certain lists that are generated by the government and by BIS. There is the denied parties list, there is the entity list, there's also an unverified list, and then fortunately BIS puts together a consolidated screening list, which is really one-stop shopping for checking whether an entity is subject to one of these end-user controls. And so it's important to have a node in your process for checking for prohibited countries, prohibited end uses, and prohibited end users, even if what you're exporting is not what you would consider to be a sensitive product. Similarly, and related to the end user, end use, and country issue, you can imagine that bad guys out there try to find ways around this. They know that good U.S. companies, good U.S. exporters are busy checking to make sure there's no prohibited country or end use involvement, and so they try to find a way around it. And that means that there is an ever-present risk of diversion. They're trying to use middlemen who will obscure the true nature of the transaction. And so BIS does expect responsible exporters to keep an eye out for red flags that might indicate the presence of one of these diversion risks. And they publish a list on the BIS website of the kinds of red flags that can come up in a transaction, and these are some of the biggest ones. You know, if the customer is evasive and won't tell you why they want to buy the item, if they're buying a product with capabilities that don't seem to match their business or the country that it's being exported to, if they want to pay cash, even though a sane person would want to take financing options, those kinds of things are red flags that the government expects you to be aware of before you make an export. And if you aren't suitably diligent, then that can result in one of the a violation of the country prohibition or the end user or end uses prohibitions. So those items that we just talked about, those are the ones that really apply to a broad spectrum of items subject to the EAR, which, as we discussed, can include pretty much any item in the United States that is not subject to the ITAR, for example. So really, really broad restrictions, very important for everybody to focus on. there is a second layer of controls that depend on the classification of your item and whether your item is on the CCL, on the Commerce Control List. If it is, then it's going to have certain associated reasons for control. The government tries to say these items are more sensitive than those items, and it's okay to export items of that sensitivity to this block of country that we consider to be our allies, but not to these other countries where we're a little worried that the government might get up to no good with those items. So this is the part that it really depends on where the item is on the Commerce Control List and what country you're sending it to. So we're going to spend a little time talking about this. At a very, very high level, in order to determine the classification of an item that you want to export and therefore figure out what kinds of controls apply to it, the first thing to do is make sure it's not subject to a different regime, for example, and predominantly the ITAR. If it is subject to the ITAR, then you're looking in the wrong regulations and you'll need to attend the ITAR webinar that's coming up. If it's not on the USML, then you're going to ask if it's subject to the EAR and the topic of the conversation we're having today. If the item isn't subject to the EAR, and remember I said, for example, that information that is the product of fundamental research or that satisfies the definition of published is not subject to the EAR, then we're going to put it in a bucket of items that are not subject to regulation. That's the term that people use in the industry, NSR. It's generally a good thing, generally means that things can be freely exported, but not always. There are some traps for the unwary associated with NSR items. They're not completely non-subject to the regulations. So we'll talk about that a little bit more in a moment too. But for now, one big bucket, not subject to the regulations. If the item is subject to the EAR, then we have to look and see if it's on the Commerce Control List. If it's not actually on the Commerce Control List, but it is subject to the EAR, then it goes in a second bucket, EAR 99. And that, generally speaking, is going to be items like rubber gloves, items that don't have any particularly sensitive properties, but we do still want to regulate their export for various reasons. And finally, if it is on the CCL, then you have to figure out something called the ECCN, or the Export Control Classification Number. And we'll talk a little bit about how to do that. So the three buckets, not subject to the regulation, EAR 99, or on the CCL, these are important because they describe a different level of control. If it's not subject to the regulation, and we talked about fundamental research, published patents are another example, then it's freely exportable from an EAR perspective. The EAR is not going to require you to have authorization to send it out of the country, but there may be special rules emanating from other regulations like OFAC, which, generally speaking, controls transactions with sanctioned countries like Iran and sanctioned parties like people who we think are involved in global terrorism. So even if you're engaging in an NSR transaction, you have to make sure you're right with OFAC, and that's the subject of another webinar later this month. EAR 99, no license required. That's great. That's generally true, unless one of those country end user or end use prohibitions that we just discussed apply. So even with the EAR 99 items, you always have to think about the country, the end use, and the end user prohibitions. And then finally, if it's on the CCL, that means it's going to have an export control classification number, 5 digits, or letters and digits, XXXXX. And items that are on the CCL sometimes are no license required, meaning you don't have to identify a license or a license exception. And sometimes they do require a license or a license exception. It's going to depend on the destination and on something called the reasons for control. So let's talk a little bit about the Commerce Control List and how you navigate it. As I mentioned, this is a truly giant list that describes a whole variety of different items. There are 10 categories, so you can see how broad the universe is. 0 is really a mess of a category, frankly. It includes nuclear materials, facilities, equipment, and also a whole bunch of stuff under the miscellaneous tab. Miscellaneous includes things like handcuffs, for example, which it might not occur to you to look for in category 0, but that's where they are. So 10 categories, 0 through 9, materials, material processing, electronics, computers, avionics, marine, all kinds of stuff separated into categories. And then within the categories, there are groups. to describe different types of items, basically hardware, end items, and equipment. In Group B, equipment that you use for test and production and inspection purposes. Materials in a different category, Group C. Software in Group D, and technology, which means information, in Group E. So when you are looking for your item, the first thing you have to do is try to figure out which category it's most likely to be in. So if you have an aircraft engine, then that's a propulsion system. It's likely to be in Category 9. If you have a chunk of titanium, then you've got a material. You're probably going to go and look in Category 1 first. And you have to figure out which group it's in. Is it information? Because if it is and it's related to an aircraft engine, then that would be 9E, and so on and so forth. So 10 categories, 5 groups. And when you actually read the CCL, and we're going to look at a few excerpts in a moment, you're going to find that there is something called an export control classification number for each item. And the first, it has 5 alpha, it's an alphanumeric sequence of 5. And the first entry is a number that describes the category. Then there's the group. And then comes something called the reason for control. And there are various different reasons for control. You can see them listed on the slide: national security, missile technology, nuclear non-proliferation, et cetera, and those basically correspond to different levels of scrutiny and different levels of concern we have about the export.
And Tahlia, maybe this would be a good time for me to interject with a question that just came in, if that's okay with you. The question is a very specific one, and that is, would a calculation spreadsheet be considered Group D software?
I think that would depend on exactly how the calculation spreadsheet operates. But it is more likely to be technology than software. But we would have to look at the definition of software and understand more about the operation. The thing that is the algorithm that is being used would certainly constitute software, but the information in the spreadsheet, the information generated by the spreadsheet, would be technology. If it satisfies the definition for technology, and I don't know that it does because I don't know what's in it exactly, but assuming that it did, and the definition of technology is information that is required for the design, development, production, manufacture, et cetera, of controlled items, then the information in the spreadsheet itself would be technology, but it is possible that the algorithm would constitute software.
Great, thanks, Tahlia.
Simple question, complicated answer, and that's just the EAR in a nutshell. Okay, so what do they look like, these CCL entries? Here's an example, 9E991, that's the ECCN, and you remember that 9 has to do with propulsion systems, E has to do with technology. So this is technology for the development, production, or use of equipment that is controlled by, and this is typical of the EAR, it references you back. It doesn't use words, it uses cross-references back to other sections of the EAR, 9A991 or 9B991, which happen to be aircraft engine-related, aircraft-related items. So when you see these double commas that are all over the place here, speech marks, technology, development, production, that means that the term is defined, and you have to go think about how the term is defined. So anyway, that's what it looks like. You see at the top there's an ECCN, and then there's a title. And then it gives you the reasons for control, and in this case, AT, which means anti-terrorism, which is actually a pretty low reason for control. And then it lists some certain license exceptions that, in this case, are not applicable, NA, so you don't get anywhere with those. And then in some cases, it will list the items controlled. But in this particular case, it tells you that the items that are controlled are the ones that are listed in the heading. So that's one kind of CCL entry you might see. Other kinds of CCL entries you might see, and I apologize here, the resolution isn't very good, but you'll be able to see it better in the PDF, which you will receive afterwards, and that are important to know about, are 600 series entries. A 600 series entry is an entry in which the third digit is a 6, so 9A610, or 2E6 something something, or 1A6 something something. The 6 tells you that it is 600 series, and what that means is that it is a munitions item, a military item that has migrated from the ITAR to the EAR during the last few years' process of export control reform. You remember I said that the ITAR trumps the EAR, so if an item is subject to the ITAR, then you have to think about that first and follow the ITAR controls. And similarly, 600 series items are considered sensitive and tend to be subject to more controls than other items. And so it's important to be aware of what a 600 series designation means. It should be a big red flag that means that you may have additional controls on an export. And likewise, items that are in this category, 9X515, spacecraft-related items, are also more sensitive and need to be scrutinized carefully. So here is that business of trumping and order of review. So when you are trying to decide how your item is classified, and that's what this whole section of the presentation is about, figuring out how an item is classified so that you can consider what controls apply to it, the first thing you do is figure out if it's subject to the ITAR. Have to do that first every time, because if it is, and you get it wrong and you decide that it's subject to the EAR, you're going to be using entirely the wrong licenses and license exceptions, and that means that everything you do will be a violation. So you've got to figure out whether it's ITAR or EAR first. Once you've decided that it's not ITAR controlled, then you turn to the EAR, and the first thing you have to do is look at the Commerce Control List, which we've been talking about. And within the Commerce Control List, the first thing you have to do is figure out if it could be 600 series or 9X515, because if it is, then those entries have higher controls, and it's important to know about that up front. So you take a look first, you figure out which category might apply. For example, is it propulsion related? So if it is, you're going to go to category 9. You figure out whether it's an end item or technology or software, and then you look at that group. So 9E, for example, for aircraft-related technology. And then you're going to go first to 9E6 and check out whether it is controlled by the 600 series. And only after you've done that do you turn to the other parts of 9E, 9E9, 9E1, etc. And you go and look at the items there. And if you don't find it anywhere on the CCL, then you're at liberty to conclude that it is EAR 99. But you have to proceed in this order in order to classify your items. Of course, you may be in an industry where the items are never yours. You might be a logistics provider or a service provider. And in those cases, you're going to have to rely on the manufacturer to classify the items for you. And it's important that you do ask them for the classification of items that you're handling, because you don't want to make a mistake and export those items or share them with a foreign person or put them on a part of your network that is accessible to foreign persons without being sure that you know the classification and the authorization for those exports. The other feature of the CCL that I'm just going to touch on briefly that is important to know about is specially designed. So sometimes, in a nutshell, the item is enumerated. You can see it right there. For example, here you can see that gallows and guillotines and electric chairs are specifically enumerated by name. You know that they're controlled. You can find them very clearly. In other cases, items are not specifically enumerated, but they are described by a specially designed paragraph. And in that case, there's a very complicated analysis that you have to go into of whether the item is specially designed for a particular purpose, and if it is, whether you can release it from control by looking at the definition of specially designed. I'm not going to talk about that for much longer here, otherwise we'll be here all day, but there's some pretty good information in the package here on specially designed and the releases that apply. All right, so what have we done? We have, in our imagination, we have scrutinized the CCL for the item we want to export, and we have figured out where it is enumerated on the CCL. Unfortunately, we've concluded that it's not subject to the regulation. It's not NSR. It's not fundamental research, for example. It's not EAR 99. It's on the CCL. We've figured out the ECCN. And now what we have to do, if you look at the little flow chart here, is determine the reasons for control. We're not done yet. And if you're feeling exhausted, yes, it is an exhausting process to classify your products and figure this stuff out. That's normal. So you determine the ECCN, and then you have to determine the reason for control. And then you have to go to something called the Commerce Country Chart in order to figure out whether you need a license or not. So let's take a quick look at that process. When you're looking at the CCL entry, you're going to see next to the ECCN a reason for control. So if you look at this slide, you can see 2E003 is the ECCN. It's a type of technology because of the E. And the reasons for control are NS and AT. NS is national security, AT is anti-terrorism. So we want to figure out whether we can send 2E003 technology to Spain, for example. You see here that it says NS applies to the entire entry, and it says NS column 1. That means national security column 1 on the commerce control chart. So you go to the commerce country chart, and you can see here that the commerce country chart has the reasons for control across the top, and it has the countries down the side. So we've got something that is controlled for NS column 1. We want to send it to Spain. You look across from Spain to national security, the first column. There's an X in the box. An X in the box means that you must have a license or a license exception in order to export that item to Spain. By contrast, if you were looking at AT for Spain, right, because this item is controlled for NS and AT, so you have to check both. When you look across to AT for Spain, you see there's nothing in the box. That means it doesn't require a license for AT reasons, but it does for national security reasons. So you do have to get a license or identify a license exception. So to recap, you look at the ECCN, then you look at the reason for control, and then you look at which column of the reason for control applies. You go to the commerce country chart, you find the country, you scroll across to the reason for control, and you see if there's an X in the box. So in this case, 2E003 is license required to Spain. We use license required to describe a situation in which authorization is required. It should really be AR, but for whatever reason we say LR. It doesn't necessarily mean a license. It can include a license exception, but you require some kind of authorization, a license or a license exception. And then 9E991, by contrast, is no license required to Spain because it's only controlled for AT, and there is no X in the box for AT. So we've determined that we need an authorization of some kind to send this item to Spain. What are we going to do? Well, there are two choices. It's not no license required. So if you think back to the earlier slide, that leaves getting a license or finding a license exception. License exceptions are described in Part 740 of the EAR, and there are a whole bunch of them. Each one is quite complicated. You have to be prepared to read very carefully the description of the conditions for the application of the license exception. Some of them are even more complicated because in addition to having to satisfy the conditions that are described in the license exception, you also have to look and see whether they are described in the CCL entry. So for these ones, LVS, GBS, CIV, and TSR, they have to be written on the page under the ECCN in order for you to use them. And sometimes, as we saw earlier, they say NA. If it says NA, then you can't use them. There's no point in even reading the conditions. If it says that they are applicable, then you have to go and look up the conditions for using them. And that's true for all of the others as well. You always have to read very carefully to determine if the conditions are satisfied. Once you've determined that you have satisfied the conditions for using a license exception, even though it's not a license, it's a license exception, you still have to make a record. And that record needs to reflect what you exported with the license exception, where you exported it to, how you knew you were eligible, so you have to include information that shows you satisfied the conditions, and you have to keep it for 5 years. There are some items that you just can't use license exceptions for. I've written down some of them here on the slide. And 600 series items are always a question. You always have to read very carefully to figure out if a license exception can be used with one of those formerly ITAR munitions items that are now in the 600 series. There's an exception here that you can read. I'm not going to dwell on it because we could talk about it all day, but you can get a sense from looking at the slide how much text there is associated with each exception and how carefully you have to read. This happens to be one here that often is used in order to allow you to take a laptop out of the country with controlled information on it. So that's a good one to know about. So what are you going to do when you use a license exception? First, check to see if it's list-based, one of those ones at the top of my chart. Check that your items can be exported under a license exception. Check whether the other conditions are satisfied, and make sure you have a record. What if you can't use a license exception? Well, then you're going to want to apply for a license. For those of you who have spent a lot of time in ITAR land, the good news is that EAR licenses are free. You don't have to pay a fee for them. You have to register and get a company identification number, and then you can use the online system at Snapper, at the hyperlink there. Much like with DDTC, like ITAR licenses, you do have to identify the parties to the transaction, and that includes you, the applicant, the person seeking the license, the purchaser, intermediate consignees like freight forwarders or banks that are going to be holding the property temporarily, the ultimate consignee that is going to actually receive the item, and the end user, anyone to whom the ultimate consignee is going to transfer that item. Then you have to have the ECCN, so you have to know how it's classified, otherwise you can't get a license. And you also have to specify the quantity and the value that you intend to export. These licenses are very, very, very specific. They only cover particular items, particular quantities, particular values, and particular recipients, parties to the transaction. The end use, and in some cases, you also have to attach a bunch of supporting documentation. You can read all of the conditions in Part 748 of the EAR. Licenses used to be 2 years under the EAR. They're now 4 years, which is a good development. And they sometimes have additional conditions built in. So when you receive a license, it is critical to read it really carefully and figure out whether BIS has imposed any additional conditions on the license. And then you're thinking, hooray, I got my license, I've got my exception, I'm done, right? But no, unfortunately, you're not done at that point. In addition to identifying an applicable license or license authorization, you're going to have to do some additional things. One of them is filing electronic export information, which tells the government what you've exported and under what authorization, how much of it, and at what value, so that they can keep an eye on the trade deficit, amongst other things. And that applies basically to all exports that are valued over $2,500 per HTS number, even if the items are NLR. You also have to mark your commercial invoice with something called a destination control statement. And the purpose of that, and we're going to look at the text in a minute, is really to prevent diversion, so that when your foreign customers or the entities outside the United States receive the item, they're being put on notice that U.S. export law is sticky and that it follows these items, and that they should not put those items straight on a plane and send them to Iran or send them to another country for which a license is required. You've got to keep an eye on how much you've sent out, how much it was worth, so that you don't exceed the value and quantities, and on the expiration of the license, so that you don't start exporting after the license has expired. And then you have to keep records. Basically, all of the documents related to the export need to be preserved for 5 years. So it is quite a large obligation. Once you start exporting items out of the country, there are a whole heap of obligations, and it is important to keep an eye on all of them so as not to violate the EAR. Here's the destination control statement I mentioned. I won't dwell on it, but basically all of that text, you've got to find a way to get that onto your commercial invoices. That is a requirement. Failure to do it is a violation of the EAR. And we talked about record keeping a minute ago, so you can come back and take a look at that slide, but there are very serious record keeping obligations. BIS does do company visits. They may turn up on your doorstep if they have reason to believe you're exporting. They may come just to give you a friendly discussion of EAR requirements. The Department of Commerce is very good about that. They really do try to educate people. And they may ask to see your records. They may ask to see your policies and procedures. If you are availing yourself of the privilege of exporting from the government's perspective, you need to be prepared to show them that you're doing it in a compliant manner. So it is important to keep an eye on these things. Okay, so that was all export, the whole export regime of the EAR. And there is another area of the EAR that is particularly important if you are doing business in the Middle East, and not only the Middle East, but also some countries like Singapore and Malaysia, that engage in boycott-related activity, particularly towards Israel. So anti-boycott requirements are a whole other part of the EAR, and the basic purpose of this part of the EAR is to make sure that U.S. companies and indeed their subsidiaries overseas don't support boycotts that the U.S. government has decided are unsanctioned, that the government doesn't approve of. And the biggest of those is something called the Arab League boycott of Israel. So essentially there are countries that boycott Israel. Israel is an ally of the United States. We don't approve of it being boycotted, and so our government has set about to try and thwart that boycott. And the way they do that is to tell U.S. companies that we cannot in any way support that boycott. What does that mean in practice? Really, in practice, it means that you have to, if a boycotting country or indeed another country asks you to take some action that is motivated by their boycott of Israel, to, for example, not send them any goods that come from Israel, or not send them any goods that pass through Israel, or some other request like that, and sometimes they're obvious and sometimes they're less obvious, you have to report those requests to the Department of Commerce, and of course you have to refuse to comply with them as well. The requests can come in many different forms, some subtle, some less. They can be in a variety of different documents. They can be little hidden clauses in purchase orders, or letters of credit, or contracts, or invitations to bid. And so it is very important to review those documents carefully to make sure they're not asking you to do something that is motivated by their desire to avoid any kind of economic activity with Israel. You can take a look at some of the examples here on this slide. I'm going to point out one that is less obvious than the others. For example, a letter of credit requirement here, which is saying that in order to get a letter of credit from this foreign financial institution, you have to provide a signed statement from the shipping company stating the name, flag, and nationality of the carrying vessel and confirming that it is permitted to enter Arab ports. Well, you don't see the word Israel there anywhere, so it's not so obvious, but essentially an Israeli flagged vessel would not be permitted to enter Arab ports, and nor would vessels flagged under certain countries that are considered to be close allies of Israel. So that one would be a prohibited boycott request. I'm not going to talk about this in detail today because my mission is to talk about BIS, and this is really a Department of Treasury issue. But while you're thinking about boycott issues, you should know that the Department of Treasury also requires reporting of operations in certain countries. The countries are listed here. They are countries that maintain a boycott against Israel. And there can be some pretty severe consequences for not complying with these boycott regulations. Okay, quick talk about investigations and disclosures before we get too short of time. When you are engaging in export activities, the government has a whole bunch of expectations. And it includes that the leadership will be committed to complying with export regulations, that as Melissa mentioned earlier, you will have a good export compliance program to educate your employees and prevent them from violating U.S. export laws, that you give them real training, like the training you're getting today, which hopefully you're finding meaningful, and that somebody at the company regularly checks to make sure that indeed you are complying, audits to make sure that the policies and procedures are working and that they're not broken. But as part of that, the government expects that companies will have a mechanism for employees to report problems, to say, hey, I'm concerned that we did something wrong, so that that problem can get fixed and doesn't reoccur in the future. And in order for it to get fixed, the company needs to do an investigation. That needs to happen pretty close in time to the violation, before all the witnesses win the lottery and leave the company and go to live on a beach somewhere, and before all the documents disappear. And they also expect that if somebody in the company is just a bad apple and wants to, for example, boost their sales numbers by arranging for things to be sold to Iran when they're not allowed to be sold to Iran, that that person will be punished and gotten rid of so that the company doesn't have an ongoing problem. And so this bottom part of the chart of government expectations has to do with investigations and disclosures. Investigations can start for many, many different reasons. It's important to know that third parties sometimes do report other companies to the government for violations. And when you're involved in export transactions, typically there are a lot of other parties who are aware of what you did. Freight forwarders are an example. They have their own obligations, as we mentioned before, to make sure that items are not improperly exported. If they engage, if they help you or help a company to export something intentionally or unintentionally under circumstances that weren't lawful, they can get in trouble too. So sometimes third parties report. Sometimes BIS comes and visits and notices something wrong, and sometimes you find it through an employee report or an audit. If you do find something amiss, then it's critical to figure out what happened, when it happened, and who was involved, not so that you can blame people, but so that you can understand the root cause of the violation. This is perhaps the single most important thing to the government, is making sure that companies really get to the bottom of why something went wrong, what the root cause was, and that they fix it, that they really come up with a corrective action that is going to address the root cause and make sure it doesn't happen again. And then, if it's appropriate, the company might choose to voluntarily disclose the violation. Or it may choose not to disclose it. In most cases, disclosure is voluntary, not all. And it may just decide to do an investigation and document what happened and fix it, but not disclose it to the government. Even if there's no violation of law, in order to avoid violations in future, it is important to go through the same process of figuring out what happened, why it happened, and fixing it. And a government does expect that a healthy compliance program will have those kinds of situations and will have memoranda documenting what it did to investigate. So what about this disclosure business? Well, there are two types, voluntary and mandatory. Mandatory disclosures, there are not many of them under the EAR, but there are a few circumstances. There is something in the EAR that's really important to know about called General Prohibition 10. It's in Part 736. And this would kick in if an item has been improperly exported, you made a mistake, something got sent somewhere it shouldn't have, and then the item needs to be used again. Perhaps it needs to be sent back for warranty purposes. Perhaps it needs to be sent on to a different end user. Perhaps it needs to be modified in some way. Something has to be done to that item that was improperly exported. If you go ahead and do those additional things to that item knowing that it was improperly exported, you have violated GP10, and now you have a double violation, the original improper export and the GP10 violation. And so to avoid that double violation situation, you're expected to approach BIS and say, hey, we improperly exported this item. We need to take some action with respect to it. We're going to disclose. Please give us permission to take this additional action. So in those circumstances, disclosures is mandatory. You have to do it before you can take the additional action with respect to the improperly exported item. It's also the case that you need to disclose if you are going to submit a license application that involves an item or a purchase order or a contract that was involved in a prior export violation. If you don't disclose in those circumstances, then not mentioning that issue in your license application is a material omission. And a material omission to the government is a serious business. It's a violation. It's lying to the government by omission. And that obviously is something that we don't want to happen. So there are some mandatory disclosures. Setting those aside, you find a problem, you have an option to voluntarily disclose to the government and say, we made a mistake, this item was improperly exported, we fixed it, please forgive us, basically. And the reason you might choose to do that is that it is a mitigating factor that reduces penalties. It's also important in the case of serious export violations that might actually threaten national security, some very sensitive item going somewhere it shouldn't. In those circumstances, it's kind of a patriotic duty to disclose because you don't really want the government to be unaware of the national security concern that arises from the violation. When you do disclose, you usually file a brief letter that describes at a very high level that you're aware of a problem. That's an initial notification. And then 180 days later, the Department of Commerce expects to see a fully developed report describing all the circumstances and what you did to fix the problem. That's called a final disclosure. If you can't get it done in 180 days, for example, if it involves a really complicated information technology system with hundreds of users in dozens of countries and thousands of files, then you can apply for an extension of time and describe what you've done and why you need an extension. So the mitigation of penalties that I mentioned for voluntary disclosure, this is real, and it really can make a significant difference. BIS recently adopted a matrix that explicitly describes how much financial benefit you might receive from filing a voluntary disclosure compared to if somebody else tells the government or they find out themselves and come after you. And you can take a look at those numbers here. It's important to bear in mind that penalties under the EAR can reach $284,000 per transaction. And so if you're getting a benefit of one half of the transaction value and it's capped at $125,000, then that obviously is a significant benefit. And that doesn't mean that they will fine you $125,000 per violation. It just means that that's the maximum that they can impose. They may choose to impose nothing. And many, many voluntary disclosures indeed result in no penalty at all. You can take a look at this in more detail afterwards. I want to leave time for questions. But when you do file a disclosure, there are in the regulations specific requirements. There's content the government expects to see. And it's pretty common sense if you stop to think about the purpose of a disclosure. They want to know exactly what was exported, what its ECCN was, what it's capable of doing, how much it's worth. They recommend that you take a look at other similar transactions that might have occurred within a 5-year period. You might choose not to do that, and they might come back and ask you to do it. So oftentimes it makes sense to do it up front. They ask you to identify all the parties and include any relevant authorizations and supporting documents like shipping documents. And then, as I mentioned before, perhaps the single most important part in my experience is the root cause and corrective actions. Government really wants to know you fixed the problem so it can't happen again. And so you really need to provide a very detailed account of what went wrong and what you've done to fix it. And it's really important to make sure that those promises you make about what you did to fix it, that they get done. That you don't just say, well, we decided that we would reconfigure the entire ERP system to automatically put the destination control statement on every commercial invoice or whatever it is, and then it doesn't happen. The IT director leaves, and the corrective action doesn't get implemented, and everybody forgets about it, and then 3 years later you have the same problem. At that point, the government's going to be really upset because you promised them you'd do something and you didn't do it, and then you had another violation. So very important to make sure the corrective actions get implemented. There's also a section where you can talk about mitigating factors. Those are identified in the regulations. It's important to look at those. And then it has to be certified. Somebody responsible at the company needs to sign it in order to verify to the government that it's true, that it's accurate, that we're not just making things up, and so that the government has somebody on the hook if there are any inaccuracies in the disclosure, particularly if they are willful inaccuracies. So it's a pretty big deal for the person signing the disclosure, and it is important, therefore, to make it as accurate as you possibly can. I think I mentioned most of these tips for making a successful disclosure. It's really important to be accurate. Being accurate means you probably want to have some kind of documentary proof for any essential facts that are in the disclosure. If you're not sure about the ECCN, remember they want a description of the goods. Then one option is to file a classification request and request an extension of time while you're waiting for that classification request. I didn't mention earlier, and I should have done, you can, if you are in doubt about the classification, if you've really tried hard yourselves to classify the item and you can't, you can submit a request to the Department of Commerce to classify the item. And they will do that. If you are not sure whether it's an ITAR item or an EAR item, you don't submit a classification request, you submit a commodity jurisdiction to the Department of State. But if it's a matter of where it falls on the CCL, then that's a classification request. You can look at this more closely afterwards. I do want to emphasize on corrective action how important it is to not promise what you can't deliver and to make sure that corrective actions really get implemented. A lot of companies have gotten in some pretty serious trouble by having multiple disclosures of the same issue and never properly fixing it, and sometimes not fixing it at all. That really, really, really does, with good reason, upset the government and is an important way of getting yourself in very, very hot soup indeed. So if you're going to disclose, make sure the corrective actions make sense and make sure that they get done. Okay, and so what happens if you don't listen to all of this good advice, or somebody in your business doesn't get the memo, or something just happens in the press of business and it is sometimes difficult to avoid violations. There's a lot of rules to comply with. What happens? You submit the disclosure, or the BIS finds out by some other means, and they can decide that the matter is suitable to be closed with just a warning, just a slap on the wrist, but they can also impose a penalty. And if they think that there is some really willful, egregious, intentional conduct in the matter, then they could refer it to the Department of Justice for criminal prosecution. Companies that have export violations could, in theory, lose their export privileges. They could be prohibited from engaging in international trade. They can lose eligibility to receive government contracts. The risk of this is getting increasingly large. The Department of Defense is considering itself adopting rules that make export violations a disqualification for government contracts. There may be a mandatory external audit, or they could appoint somebody to make sure that you improve your compliance program. That doesn't happen as often with BIS as with the Department of State, but it does happen from time to time, and the recent ZTE enforcement action is a good example of that. You may find that licenses that you submit get very delayed because the government is very concerned about your ability to comply with the conditions of the license, or they may deny licenses altogether. And then, of course, there is the monetary aspect. And for criminal violations, that can reach $1 million. But even if it's unintentional, even if it's an innocent mistake, but nonetheless a violation, you can be penalized up to $284,582, which is a really silly number that has to do with adjusting for inflation, but let's call it $285,000, or twice the transaction value for each violation. So these penalties really can add up. There have been and will continue to be quite a lot of enforcement actions. OEE, the Office of Export Enforcement, which is the office at within the Department of Commerce that deals with EAR violations, is pretty active. And they do have agents out in the field trying to make sure that national security is not threatened by export violations. And they do bring a fairly large number of enforcement actions every year. Some of those involve criminal conduct and very highly sensitive materials being exported, and some of them involve much less sensitive items. And sometimes they result in big penalties, and sometimes they don't. But they are active. And these are just a few examples of some of the more stunning recent enforcement actions. ZTE Corporation, which is actually a Chinese corporation, has a U.S. branch, but it is a foreign corporation. They re-exported U.S. telecommunications equipment to Iran and North Korea, and over a long period of time, and allegedly with knowledge, and that led to an extremely large $1 billion of fines, as well as an enforced compliance program overhaul. So that's, a pretty dramatic recent action, underscoring how important it is for foreign corporations to be aware of EAR regulations as well. There are lots of other examples. These ones, when you read the details, these all really do involve pretty egregious action. The company being aware that things were going on and not taking action to stop it. But there have historically been additional actions that don't involve such egregious conduct. So I wouldn't want you to get the impression that BIS only enforces in very severe cases. There have been cases of EAR 99 telecommunications or EAR 99 cables being exported to prohibited entities, resulting in fines, for example, even though the item itself is not sensitive. And so with that, I think I'm going to open it up for questions.
Great. Thank you so much, Tahlia, for sharing your fantastic insights. This is a great overview of BIS. And operator, would you mind reminding the audience of how they can enter themselves in for a question, please?
Thank you. We will now begin the question and answer session. If you would like to ask a question, please press star 1. You'll be prompted to record your name. To withdraw your request, please press star 2. One moment, please, to see if we have any questions or comments.
And while we wait for the first audio question, we did have a couple come in through the written queue. Tahlia, the first one is, should the destination control statement be applied to shipping documents related to EAR 99 exports?
So it isn't required in cases unless the EAR 99 items are being shipped with ITAR-controlled items, in which case it is required. Nonetheless, it's a generally good practice to do it because there are, as I mentioned, these end-user, end-use, and prohibited country controls that apply very broadly even to EAR 99 items. And you may want the person receiving your EAR 99 items to be aware of those controls. Because even if you don't make a mistake, if your product ends up in Iran or North Korea, or if your product ends up being used in a terrorist attack because it was re-exported by a foreign entity that received it from you, that can lead to some bad publicity, but it can also just lead to embroiling your company in an investigation. Even if it is not the target of the investigation, that can be a very unpleasant experience and consume a lot of resources. And very often it's easier to tune the ERP system to just do it on all commercial invoices rather than trying to figure out if something's EAR 99 or not. Also, if you make a mistake about the classification and it wasn't really EAR 99 and you didn't have the destination control statement, then that just adds to the number of export violations that shipment involves.
Okay, and a second question that has come in, do these rules apply to Puerto Rico or other U.S.-held territories?
Yes. They apply to any territory that is considered part of the United States. They also apply outside of the United States in the circumstances I described at the beginning. That is, if a U.S. person is involved, or if U.S. goods are involved, or goods that are derived from U.S. goods.
Great, thank you. And operator, have we had any audio questions registered?
I show no questions. And again, as a reminder, if you do have any questions or comments, please press *1 and record your name. Again, please press *1.
And just as a quick reminder to everyone, I will be sending out a PDF of the presentation. On this slide here, you can see Tahlia's contact details or email details, as well as some links that she added to the presentation.
Oh, and I should just clarify, reading the question that came in about the destination control statement, I think it's got two parts. One was, do you need the DCS for EAR 99 items? And I think I answered that part. It also says, should it be applied to shipping documents? Under the old rule, the DCS had to be on the airway bill, for example, on the shipping documents. Under the new rule, it only has to be on the commercial invoice. Just want to be clear about that with everybody.
Operator, any questions that have come in?
I show no audio questions.
Okay, great. Tahlia, any final thoughts for the audience?
Good luck, and enjoy your international export experiences.
Great. Thank you so much, Tahlia. And again, everyone, you'll get the net replay within the next 24 hours.
Excuse me. We do have one question that just came through.
Oh, great. Thank you.
One moment. Okay. Whoever pressed *1, your line is open. I did not get your name.
Hello, my name is Venkata, and I have a question.
Go ahead. Your line is open.
Sure. Thank you.
Yes, what is your question?
Yeah, hello. Say if you're trying to export something, and then say if we export it to some party who is not on the restricted party list or like anything like that, how do we have the control? Like say, as we discussed the end use, say if we export it and then we don't know exactly what the person to whom we exported, he or she does it, right? So how do we, how do we ensure just to have some controls over that kind of stuff?
That's an excellent question that companies struggle with all the time. Different companies take different approaches based on their sensitivity to risk and on the likelihood that their product might be abused in some way. Some companies, for more sensitive products, will require an end-user statement. So if they're engaged in transactions, they ask the party receiving the item to acknowledge that it can only be used for certain end uses, to say that it will not be used for prohibited end uses. Sometimes they will require, if you have a long-term relationship, some companies ask for an annual end-user certification that just reassures them that that party understands and certifies that they will not use it for a prohibited purpose. In some cases, for some ECCNs, end-user certificates are required as a condition of a license or a license exception.
Okay.
But for non-sensitive goods, there is no requirement to interrogate the recipient, but some companies do it as a best practice. And if in terms of liability, if there are red flags and you don't investigate them, then the department might consider you liable for the improper end use. But if there are no red flags and you've done your due diligence, then that's really as much as the department expects you to do.
Okay, that really helps. Thank you.
I show no further questions.
Great. Well, thank you again, Tahlia. We really appreciate you sharing your insights into BIS and EAR. And for those of you on the line who are with us for the entire 17-part webinar series, we will talk to you on Thursday. We will learn all about ITAR. Thank you again, and have a good afternoon.
My pleasure. Thank you.
This concludes today's conference call. Thank you for participating. You may disconnect at this time.